Our next speaker is Ryan. Ryan Openshaw is a senior associate in our litigation team. He has more than 10 years' experience as a litigator and is adept at in complex, high-value commercial disputes, both domestic and international clients. Ryan has developed considerable expertise in dealing with commercial and contractual disputes, with particular focus in both the oil and gas and commercial property sectors. Ryan deals with proceedings both in the Scottish and English courts, as well as domestic and international arbitrations. He's going to talk to us today about preventing this activity.
Today I'm going to discuss the growing threat of business disruption. So with primarily a focus on the legal steps that businesses can take to stop activity which is potentially harmful to their business. So you've all seen lots of high-profile activity in recent years from groups like Extinction Rebellion, Just Stop Oil and Insulate Britain. And recent market research suggests that many in the industry now see this as a serious and growing concern to the business. At the moment, the industry is obviously trying to strike a delicate balance between transitioning towards renewable energy sources whilst also maintaining affordability and security of supplies. What we're likely to see is competing interests, some increased tensions, and potentially an increased number of people who may be inclined to some level of civil disobedience. There was actually a recent survey done by a group called Opinion Research, which suggested that 1.7 million households were planning to strike on payment of energy bills. Now, whether that happens remains to be seen, but what it potentially does do is just tell us there is quite strong feeling, gives us a bit of an indication of the mood of parts of society, and suggests that there is a real risk of strike action aimed at those who are perceived to be benefiting from the current climate. I would warn that risk is not exclusive to big global companies. Protester groups will strategize and plan the best way to achieve maximum impact with minimum effort or perhaps minimum risk to them. Path of least resistance, find the easiest way to cause most disruption. And that can include targeting suppliers, contractors, site owners, lines of transportation, etc. So underlying message would be if your business has an important role or any role to play in a project that might attract activist activity, it should be aware of the risks and it should have a plan in case that risk arises. Beyond the operational issues like health and safety issues which can arise when protester activity occurs, there's PR issues to think about as well. So where there is significant press interest, it can be a difficult job to handle the PR aspects. And that's not just at company level, but at industry level too. And I know that the chief executive of OE UK recently raised concerns that if protesters are regularly seen to have some success in causing disruption, potentially even influencing policy, then there's a risk that deters investment in the UK. In turn, arguably, that then hinders the UK's efforts to cut emissions and to move away from reliance on other jurisdictions for energy. So turning to the practical side of things, if you are faced with protester activity or the threat of protester activity, what do you do? What's important to act quickly, and what you'll be looking to do is involve the courts in granting you interim injunctions and injunctions, or if activities in Scotland, interdicts and interim interdicts. Different terminology, but essentially the same thing. I suspect you will know that essentially that's just an order from the court to stop or prevent activity which infringes on your legal rights. You will want those orders on an interim basis. Again, many people know that defended court action can take months or years. No point in raising an action. We're not going to go for the interim orders because it'll be a case of closing the door after the horse is bolted if you get orders many months down the line. The harm's already been done. So if raising an action, the first important point to consider with your lawyers is whether you have a case which justifies the orders you're going to seek. So that means persuading the court that there's a real issue to be dealt with that does justify court intervention That doesn't mean there has to be a clearly communicated threat from a particular party to your business, but there does at least have to be something that gives you what the court would consider to be reasonable apprehension that harmful activity is actually likely rather than just possible. So, the current climate, potential increased risk wouldn't be enough in itself. The court will also need to be persuaded that the activity that you're concerned about does warrant prohibitive orders. So if you have intelligence that there's going to be peaceful protests, that in itself, again, might not be enough unless you're able to demonstrate that there is reasonable apprehension that escalate something more than that. One of the aspects that the court looks at is whether your case satisfies the balance of convenience test. And that means it will ask itself which party will be most inconvenienced if it doesn't get attendance on an interim basis. Now, if your requested orders are only looking to prevent activity which would otherwise be considered unlawful anyway, or very clearly infringes legal rights, that should be an easy enough test to overcome, because it can't sensibly be argued that it's an inconvenience to have to comply with the law. The flip side of that, if the court's looking at it, is that the inconvenience to the applicant will, in some cases, be very significant in terms of potential disruption, potential losses, and courts are conscious that damages awards have to be against protester groups and protesters who are part of it doesn't have the same impact, doesn't properly compensate the applicant. Consideration will need to be given to exactly what type of behaviour you prevent and who you face proceedings against. Now, if you know of particular individuals or groups that are threatening activity against you or engaged in activity against you, that's all fine. You can name them in your court application, serve papers in a usual way. But if you're dealing with friends or different groups or that are not affiliated to particular groups, positions to be far more complex, you're probably going to have to direct your action against persons known, and if you have to do that, then defining them by the nature of activity that you're concerned about and where it's taking place. So, some examples on the next slide, and you'll see here the way the defendants in court actions are described are with reference to what they're doing and where they're doing it. So, trespassing land, obstructing access, interfering offences, but that's not an exhaustive list. Then 5 out of 10 conduct is infringement of rights. So if you're raising proceedings against persons unknown, the next slightly complex question is how you serve proceedings upon people or serve any interim injunctions that you get on those people. And courts recognise that will allow great flexibility. So if you're dealing with particular locations, defined locations, the court might be persuaded that clear, visible notices displayed at those locations is sufficient. It's kind of like the, I suppose the analogy of parking by the car park. You're deemed to have entered into a contract, so you see the signs up by pay. So it's similar to that. You're deemed to have received service papers if you've done that activity once you've entered that location, seen the signs. Now, and actually, if you've been to a Shell petrol station in England recently, you might have seen the junction notices up pubs with those doors. Not so quite clear cut if you're dealing with far larger areas. So the government, as many people know, has an injunction in relation to crossing with the National Roads Network in England and Wales. Clearly, notices of location are not practical in that scenario. So what you have to do is essentially serve people with notice of injunction as and when you've done the activity. So you might not be able to immediately face breach of injunction proceedings against somebody who's done activity, but demonstrate where the injunction become aware of someone conducting activity, essentially certain papers, they don't need to assess them based on injunction proceedings. So what type of activities can be injuncted? Well, if we look at the slide there, as I say, that the focus is really on, if you look at words like damaging, delaying, hindering, interfering, it's very much focused on the way in which your legal rights are being interfered with. No exhaustive list of that, but there are lots of activities that the protesters take. Conduct you're complaining of doesn't necessarily have to be otherwise unlawful, does have to do your legal rights in some. If you don't have a legal right not to be protested against, you have legal rights not to have property, operations, etc. interfered with. Courts do like precision and clarity, and that can be difficult if you don't know exactly what sort of threat you might be facing, so you have to describe as clearly and precisely as you can what sort of activity might be a threat to your business. There's going to be some degree of generality, and the courts will appreciate that, but they will also be conscious of the fact that you might be serving papers on as yet unidentified persons who probably don't have representation, probably don't have the technical terms and disorders. So the court will probably be quite pernickety about the exact orders that it's prepared to grant. And what happens if you've obtained orders which are then breached? Well, injunctions and interdicts are civil remedies, but if they are breached, that amounts to contempt of court, so it is punishable by a fine or potentially jail time. And in recent months, we have seen a number of insulated Britain activists jailed where their breaches have been repeated or demonstrated disregard for the court's orders that sentence is 6 months, so pretty significant. There's certainly been instances where protesters will appear in court and say that they plan to do it again, and judges with choice to close a custodial sentence. I've included some extracts there just to demonstrate that the court does try to send a message that its role is simply to apply the law. It's not making judgments on value or policy. Sometimes that's not always clear to protesters or in the media. So the court does attempt to take a bit of a PR exercise. Finally, what can businesses do? So, we've seen that the courts do take this seriously, will impose custodial sentences. The government are also taking it seriously, taking injunctions, road networks to protect others from disruption. There's also legislation in Wales which increases police powers in relation to protester activity, but that's not a substitute for having good procedures in place yourself. In all of your offices, there will be very effective security systems, and it's important those are actually implemented in practice, because if one person access to or on the website, quickly access to others. So it's very much worth having a plan of action in case you are faced with protester activity. That should cover managing communications with protesters. If you want to persuade them to think in a certain area which is safe, because there's significant health and safety issues, how best communicate that message to them, who's looking into the health and safety issues. So effectively you have an emergency response team with people having responsibility for this. Importantly, how are you going to initiate the type of legal proceedings that are discussed today? Because that's ultimately what's going to stop any ongoing activity, or hopefully prevent it from guarantee proceed anyway. But main message, act early, because that's insufficient. Stop. Questions now, rather at the end. Anybody, any questions? Happy to take any at the end if you think of anything before that. Oh, yes.
Less of a question around more of a comment. I guess putting on my renewables hat here, we too experience instances where we have potentially turning up on site. Often it can be local people, particularly in relation to onshore wind farms, which have their own controversies. And I've acted for clients who, as you say, have not put early legal structures in place, and find that on the day as they're trying to transport either turbine blades or parts of the turbine, we've had protesters lying in front of trucks. And I think on that occasion it was a case of police intervention. But I guess just another example of how not taking that early legal intervention can lead to unexpected consequences on the day.
Exactly, and you can get an interim injunction or interim interdict in place without necessarily having had to serve it on anybody yet if there's a threat. So you're saying to the court, we need this now, we need this in place, we need to be able to put up notices so that if anybody comes in, we can immediately say they're breach, we can take steps to get them removed. If you don't take that protective step in advance, then the procedure is elongated, because what we're going to have to do is go to court after they're already there and say, right, we now need interim interdict or interdict in place. They can actually defend those proceedings, so you can't kind of jump straight to the enforcement stage. Thank you.